Good evening, everybody. It seems as if there's hardly anybody in my life who hasn't given a lecture to you here, so be ready for colossal disappointment. What I want to talk about is the title, Bystander to Participant, and is this a critical time for victims? Let me tell you what the Victims Commissioner does, first of all, because it's not necessarily that well known. So I have three duties: to promote the interests of victims and witnesses, to drive best practice for them, and to keep the Victims Code under review. If this was a slideshow, which it's not, the next one will of course have my powers, and it will be empty because I don't have any. So how do we work? Well, firstly, we have a wide range of victims organisations and victims, and we ascertain what they need. So what we drive forward is never my views, it is those are the people who really need our help. Victims organisations varying from domestic and sexual abuse, antisocial behaviour, fraud, across the whole gamut. And then the other half of our stakeholders, we take these issues to. They are ministers, the judiciary, the police, the CPS, HMCGS, the probation service, etc., to try to get delivery of the rights that the victims' organisations have told us they need. Secondly, we do some research. We try to bring original information about victims' issues, and we publish them with as much gusto as we can and try to drive their implementation recommendations. You'll hear a little bit later on about our report on special measures to let victims give their best evidence with the least strain and stress. And recently we published a really interesting report in which we found 9 categories we could see of fraud victims. So that's me. What do victims need from the criminal justice system? Well, politicians who are, for instance, increasing sentences usually say that they're putting victims at the heart of the criminal justice system. As a matter of fact, everybody talks about victims being at the heart of the criminal justice system. But sentencing is not what victims are interested in. They vary as we do, and many of them really don't take an interest. They do need to be put at the heart of the criminal justice system, but in a very different way, which we are not doing, but we can do, and we should do. And I want to say how we should look at victims in the criminal justice system, re-perceive them, as it were, to better assure that they're given their rights and helped to cope and recover, which is the watchword from what's happened to them. Before I go on, let me just emphasise that nothing I say detracts from the centrality of the defendant's fair trial rights. We can draw a red circle around those. We can improve the role of victims and witnesses hugely without coming near to the edge of that circle. My 20-odd years as a defence lawyer make me very clear about that. Though nobody in the position of a victim of crime is going to be wrongly imprisoned by injustice, but victims can and do suffer injustice from their treatment by the criminal justice system, from disregard by the agencies, to re-traumatisation by the process itself. So what I said was victims can suffer injustice from their treatment in the criminal justice system, disregard by the agencies, re-traumatisation by the process itself. The government, in its 2018 victim strategy, said very clearly, often victims are a victim of the process as well as the crime. And it's easy, historically, to see why. So historians relate that in medieval times, if wealthy enough, a victim brought a claim against the wrongdoer for redress, and that was the criminal justice system. But as a centralised state emerged, it changed to the current situation where crimes are seen as an attack on doing harm, an attack and are doing harm to the state and to the public as a whole. So responsibility for reacting to crime shifted from the victim to the court. Victim redress no longer the point punishment and affirming the law. The victim therefore loses all centrality. There is no right to redress. What happens to the defendant will be done for the public good. The defendant isn't a party to the proceedings. Harm done to him is only the harm the same as done to the rest of the public. Cases can be brought whether he wants to or not. He can be compelled to testify, but you come away with nothing. Now, and this is now today too, at the centre of the process is, of course, the defendant. The prosecution prosecutes him, defence defends him, jury decides on guilt, and the judge ensures that the trial's lawful. The victim is not there in the arena. If he's a witness, though he may have injury or loss, he's not there to speak about that, but to tell the court what the defendant did. If he's a bystander to a crime committed against himself, or as academic Paul Rock described, he is witness fodder for the criminal justice system. And this is the problem. They are, in fact, not at all at the centre of the adversarial criminal process, which is carried on between the state and the defendant. However, they have suffered the crime, an intrusive burglary, broken bones, sexual abuse, the death of the loved one. Victims are the people most affected by every crime. Everyone's impacted by crime, by the way, from somewhere along a continuum, from a bit shaken as to their personal security, perhaps feeling a bit targeted. I talked to a senior police officer who'd been burgled, who tells me that he never drives home without wondering if someone's been in the house, and he's a great, rough, tough police type. Somewhere from shaken, and when it's serious crime, hurt, traumatized, or their life changed completely from a crime from which we did not protect them in the first place, and assuredly they did not want. So they are at the centre, in that sense, of the criminal justice event. They're forced by it, if they want, by the crime, if they want to seek justice at all, into the criminal justice system. There is no other place to go. So they are an involuntary participant in the crime and in the process, all the way from report to court, and they'll be affected long afterwards and long after every criminal justice professional has forgotten all about the case. Abundant research shows that how the criminal justice system treats victims strongly influences how they recover, and if they don't get what they need, it can re-traumatize them. And it's easy to see how history has left them in this position, where they might easily be overlooked by a system of which they are not a working part. So we need to see victims in that way. They are participants because they are victims, and they are entitled through that status to rights quite separate from the rights of the state. So the prosecution is done by the state on behalf of all of us. We as a society are the victims, but that doesn't realistically capture the interests of this victim with their pain. It's qualitatively different as an interest from the public with a general interest in having a satisfactory criminal justice system. It is one thing to say that the prosecution role represents all of us, and another for the criminal justice system not to acknowledge the victim's special involvement and right to be supported by that system to cope and recover from what the state didn't protect them from. And victims who are witnesses, of course, testify on their own behalf, but they also do it as a public duty. People who report crime do so because they want to help, but it's also in the public interest. The criminal justice system can't function without victims, so let's acknowledge that they're an integral part of it. So let me set out how the CJS is not supporting victims now, and just elaborate a little bit more on the thoughts about how we rectify that by just repositioning them as victims, participants who have a right to justice too, which is to say we give the criminal justice system the role of delivering two kinds of justice: adversarial justice to the defendant and another kind of justice to help restore the victim. There is space, even though the issue is between the state and the defendant, for two kinds of justice. So things have got better in the last few decades than the bare picture of being a bystander. But is it right that victims are still not at the centre of the criminal justice system? So we start off with victim support, which started up about the 70s. The women's movement emerged to challenge on behalf of women who were principal victims of hitherto hidden crimes, also in the 70s. support services from them, rape crisis centres and so on, which are there to help victims. The general kind of victim support was delivered nationally by that organisation called Victim Support. But when the PCCs emerge, victim services, though still government funded, are delegated for local commissioning to police and crime commissioners. So they do a needs assessment, they commission a victims hub with satellite specialist support services around, and they are commissioned via victim support, are commissioned for someone, but there's a market. These victim services are there to give practical, personal, emotional support for victims. Sometimes it's a volunteer visiting, sometimes it really is specialist counselling for many years. But apart from passporting through the police, which is how often people get to these services, they have nothing to do with the criminal justice system or making the situation in that system better for victims. At court, if it goes to court, there are witness care units whose job is just to get witnesses to court, overcoming practicalities to get them there. If they realise someone's vulnerable, they might refer them to the Victims Hub, but they might not. And then at court, there's the court-based witness service run by the Citizens Advice Bureau, serving all witnesses, defence and prosecution. This is court-based courtesy. It is a court familiarisation visit and a meet and greet. So there really isn't a lot in the criminal justice process itself. The best is a small cohort of professional befrienders, independent domestic violence advisors, independent sexual violence advisors, child trafficking advisors, independent victims advocates, all parts of, as you can see, pretty heterogeneous victim services for various kinds of victim likely to be badly affected. Their roles vary, but at best they can liaise with the court and the hubs and accompany the victim to give evidence. But all of these resources are very, very thin on the ground. And so little attuned to the needs of victims are some courts that they won't allow independent sexual violence advisors or independent domestic violence advisors into the court. So you will get a position where, having had these advisors with them for all practical and emotional purposes for months or even years, they're told at the most stressful time that they must give evidence without their supporter present. And they often don't know about this until they get to court, because some judges let them in and some judges don't. And there are for victims as witnesses special measures which I referred to, and these are pretty helpful. They're introduced in 1999 legislation to help intimidated witnesses, which really means intimidated by the situation, though it also means people who've got a gangland pressure on them. And also they're for people who are assessed by the police as vulnerable. And the point is to give the best evidence they can by some kind of shielding. So an application has to be made to the judge to let a witness testify, typically from behind a screen, or very rarely done, empty the public gallery. We produced a report on special measures, and we did a survey of judges who were very clear that they meant that a lot of victims who would never have been able to give evidence at all can do so with the help of special measures. But as with ISVAs, etc., only being patchily received by the court, special measures are not done very well. The police assess for eligibility to have special measures, but research in the Criminal Law Review and in the latest version of a textbook, Rook and Ward, found a huge gap, really, between the 7%, which is the estimate of how many witnesses police say are eligible for special measures, and 24% of witnesses who a simple questionnaire showed were vulnerable or intimidated. That study is quite dated, and we would hope for more soon. But nonetheless, I'm afraid it is quite a damning criticism. I meet bi-weekly with the Police and Crime Commission and Victims Hubs, obviously online, and the support is limited too, because they say the courts have a local culture about what special measures are available. So you haven't got the tuning to your needs. Usually it's a physical screen in court or a live link from a room just outside. But victims, on the other hand, are very frightened of going to court, mostly because they don't want to see the defendant and his family and supporters. And they have particular needs and wishes, which may not coincide with a curtain in the court or a live link outside. There are remote evidence centres which would meet that problem that people don't want to go to court, but they're very little used. There's something else now called Section 28, and which has got nothing to do with a different Section 28. This is about how to get people, in my view, out of the queue that there currently is for serious sex offence cases in the criminal court. So what the Section 28 provisions allow is that somebody who gives a video statement of what happened to them rather than a written one, which is many people in sexual offences particular, they're allowed to be cross-examined across a live link, and that's videoed, and then the two videos are put in a box, and then when the case comes up, that's what's used as evidence, and they are out of the list, and they can just get on with things, not least of all getting therapy with no worries about that being disclosed in the course of the case. There are some logistical problems with Section 28, but it's moving along. Now, the big thing that is supposed to help is the Victims' Code. Although there was a Code of Victims' Rights absolutely connected to the CJS, so this is where one will be looking for some kind of centrality. 2006 was the first code. Compliance has never been made compulsory. Implementation has never been pressed. The police and the CPS, who see their role in a contest over guilt and innocence of the defendant, historically saw victims as peripheral. Victims' care has only evolved, as I've described, fairly recently, and some of that legacy culture remains. Agencies feel quite free to disregard the Victims' Code, or at least to deprioritise it, because remember, their job is investigating him, prosecuting him, and it isn't about victim care. These are really serious cultural barriers to helping victims. Let me tell you what we found out about the Victims' Code. There are 12 rights. None of them are enforceable, and so they're not rights. And they're not even expressed as rights. Let me read you a bit of one. For instance, right 6, where the police and the CPS are considering an out-of-court disposal, doing some arrangement so that it doesn't go into the court system, you have the right to be asked your views as the victim and have them taken into account. Where this is not possible, the right continues. The police and the CPS will tell you why. Right 6. In an especially serious bunch of cases, if the CPS are not going to have to charge, you have the right to be offered a meeting, unless the CPS think that a meeting isn't appropriate. Part of Right 8, when attending court, is to be able to enter as a victim through a different entrance to the defendant and wait in a separate waiting room. That right continues. Some court buildings don't have separate entrances. The HMCGS will do their best. So it seems to me that my right as a victim is confined to being told why I can't have my rights as a victim on this arrangement. And bluntly, people who've had a family member killed by a hit-and-run driver can come to court, and we can't guarantee that they won't come through the entrance at the same time as that person and that they won't have to share a waiting room with him. It's clear, I'm afraid, that these are shaped for the deliverers of the rights, not as rights for me, the victim. Obviously, if occupying a separate waiting room were right, the court service would have to organise one. But as it is, they just say they will do their best. So a few more code rights to mention. Rights 3 and 6, to be provided with information about the case and updated when decisions are taken. To be referred to victim services, the right to make a victim personal statement to say how you've been affected by the offence, to be given evidence, information about the outcome of the case, and an explanation of the sentence. We analyse, my office, the Crime Survey for England and Wales Victims section, and the Ministry of Justice doesn't. They collect the data, but they don't analyse it. The latest data shows that most victims, feel the police treat them pretty fairly and with respect, but more than half said the police didn't keep them informed about progress. A significant drop over the past 5 years. That's right, 6. Quote, I was informed that the perpetrator had been arrested and released about a week after that happened. I was completely unclear about what happened next. I could have bumped into him in Tesco. Most victims were satisfied with their first contact with the police, but over a third were really dissatisfied about the handling and no news. I felt, yes, the investigation took a really long time. I wasn't kept up to date. It was a big burden. I had to call and keep asking and pestering how things were progressing. I was never told the outcome. Months passed with no invitation, no information. And my ISVA phoned for an update to be told the case had been settled weeks before, no further action, and that was the first I knew of it, and no one explained. In February 2020, the all-party parliamentary group on adult survivors of sexual abuse found time and again survivors and supporting organisations described irregular and poor quality communication from police and the criminal justice system generally. So that's right, 3, 4, 5 and 6. Only 4% of victims ever had any contact with the victim services I've talked about, victim support and the others. And even when there was a report to the police, just 10% of victims had contact with victim support services. The idea is the police refer to victim services every person who doesn't say they don't want to be referred. So entitlement to victim services right. 36% of victims dissatisfied with how the criminal justice system dealt with their case generally together. So all of these rights are rights under the Victims Code, but in 2018, the latest data of all the people who were sampled, who'd been through the criminal justice system in a case, only 20% of them had ever heard of the Victims Code. And consequently, I presume, any of its entitlements. We do an annual survey of our victims' personal statements, which look like a good thing. Right 7 to be told about the victim personal statement. For the 6th year in succession, when I came into post after my predecessor, fewer than 1 in 5 victims record being offered a VPS, and this fell to 1 in 7 in my first report. Of those who did make a VPS, only 46% felt it had been used anywhere at all. And that's the lowest level of satisfaction in the 6 years that those reports were being done. So that is altogether, folks, 8 out of 12, the key rights that are just not being delivered. We have personal complaints to the office all the time, though my statute says I can't take on any individual cases. We get a lot all the same. And we have a correspondence secretary. We are full of stories of this kind of failure. In 2009-2010, the Ministry of Justice showed that 67% of victim witnesses who'd given evidence were happy to do that again. But by 2016, although it's a different survey, only 53% said they would be likely to do it again. We did a survey, and in 2020, fewer than 50% said they would give evidence again. Under the Victims Code, those suffering the most serious crimes, intimidated or vulnerable categories that I've mentioned, and those who are persistently targeted are entitled to enhanced rights, implying greater care, earlier contact. So rape complainants are in that category, but we did a survey in 2020 which shows that far from receiving any enhancement, most rape complainants spoken to found the CJS a hostile environment. 491 complainants responded, many who reported to the police saying that they just felt disbelieved and judged from the start. 95% of the respondents who didn't report said it was because they thought they would be disbelieved because of their gender, their sexuality, or their lifestyle. You may think the ones who reported sadly prove the reservations of the non-reporters to be correct. CPS decisions to drop cases were described as devastating and often unjust because they thought that avenues had not been pursued. Evidence not considered. 14% of these rape complainants agreed with the statement that they would get justice by going to the police. 14%, were still 75% actively disagreed. The most recent Home Office figures show 42% of rape complainants would not proceed with their case. They dropped out after they got in. They went, but they couldn't stay. 44% of victims in personal violence cases went to get help, went to the criminal justice system, couldn't stay. In every kind of crime, 26% of the cases, so that's every kind of crime, stopped because complainants withdrew their support. This is triple the percentage from 2015. So what we're seeing is the failure to deliver victims' code rights, poor treatment, contributing to low confidence, and of course, court backlogs contributed to by COVID, but they're long before COVID, are making matters worse. The average for a rape case, and I'm sorry to talk about rape a lot, but we've done the most work about that for pretty obvious reasons about what's in the air now. And the average for a rape case is 700 days from report to getting a court listing date. And there are lots of complainants who are sent to court, sent away again, sent to court to give evidence, sent away again. There was recently a joint report from the inspectors of constabulary and the inspectors of the CPS, which found that out of their sample, which was only 54 cases, 32 had been taken out, put in, taken out, put in, and one case, unbelievably, had 21 appearances of that kind, in, out, 21 times. And they found, too, very interestingly, that only 1.9% of their sample of these cases had been delayed by COVID. So the failings I've set out long predate COVID and will continue beyond it, and we'll continue to lose victims for justice unless there's a change. So this is, I think, where victims are now. So one thing I think I should quickly confront, and it's hard to know where to put it in this address, is the question of who is a victim. There being a view at large sometimes that a person doesn't become a victim until the jury's returned a verdict, and consequently no help should really be given to them. So my clarity is that, of course, the right term is complainant in a trial, but most times the complainant is undoubtedly a victim, somebody who's suffered harm. What's in dispute is often whether the accused did it, had the mental element that was appropriate, or whatever the issue is. That's most trials. In some, the question is, was there a crime? For instance, if the defence to rape is consent, in an assault of the defence is self-defence, and these cohorts, particularly rape, of course, seems to fog the issue of the need for support for victims of crime. If you look at these equivocal two groups, people are very demeaned and damaged by being beaten or by being used as objects by others, and are very often ashamed to talk about it. This criminality is very traumatizing, and many will need considerable help and support to cope and recover for what undoubtedly has happened to them, and they are satisfied is criminal. Rook and Ward, the textbook on sexual offences, sets out the range of psychological reactions to sexual assault: anxiety, self-hatred, self-blame. 94% of victims of sexual assault have PTSD by 12 days after the offence. 51% at some time afterwards, and still had it 2 years later. And many rape complainants have already been victimised. A lot of research, again, in Rook and Ward, shows that people with a history of childhood sexual abuse, mental health problems, or learning disability are far more likely to be abused. I sometimes think that predators are better at spotting the vulnerable than those who should be safeguarding them. So it isn't appropriate for you or I to deny support to people who may well be victims. We can't decide whether somebody is a victim or not, and it's not possible to wait till the trial's over to decide if this complainant is a victim, affected by a severe beating, say, in a fight they didn't start. If it's correct, they'll need support And the only possibility is to give that support at the start. And I think we did take this decision when we allowed special measures to be granted automatically for a lot of complainants now fully 2 decades ago. And it's the only default position, in my view, that there is. So we just have to tackle the dilemma that victims' rights aren't working, aren't enforceable, and are rights only so long as the criminal justice agencies want you to have them, basically. So shortly, there'll be a victims' law. And just one little anecdote. We spoke to some Ministry of Justice officials looking for targets for to underpin the victims' law, which is in process now. One was a 50% increase in awareness by victims of their rights. I said, that given that awareness is 18% now, that would come to 27%. And that was so low as to look silly as a target. They said they'd had a real battle with the police and the CPS to get that target at all. And I think that just says it all. So, what do victims need and what works? The victims vary like you and me, and a lot of emotions, loss, confusion, despair, resentment, fear and hope. Up here, how can the CJS help them to cope and recover? Well, the first thing that victims want, consistently across lots of research, is validation that what happened to them is wrong. They want their pain to be taken seriously. They don't want to be blamed for what happened to them, whoever they are. They feel somewhere on this continuum between demeaned, abused, targeted, traumatised. Some, as the NHS accepts, in need of lifelong care. They need the authorities to tell them they're a valued citizen and to say that they will do all they can to restore their sense of safety. The police do, I think, appreciate that they represent us all when they go out to a call like that. And you may have noted that satisfaction with police attendants is quite good. They do go, they do well, and they are competent and pleasant and respectful when they do so. The difficulty is that within a couple of weeks, as you saw from the example, people just haven't really heard from them. But that's very clear, I think. Trauma is fundamentally an experience of powerlessness, and the experiences that counterbalance that powerlessness are being given information, working out a narrative, asking questions, and being brought in to how the criminal justice system works. We did a report about what works, and just to kind of reassure you and sort of unreassure you at the same time, victims want what's in the victims code, more or less. We found information on request and communicated well, regular updates on decisions on cases, not the police saying they'll be available on Friday and then being on the wrong shift with no other officer having a clue, an explanation of how the CJS works, collaborative working across the agencies so that they don't have to go to anybody they don't know, and they don't know who to go to, professional victim services, and most importantly, procedural justice, which just is procedural justice, a respectful acknowledgement that wrongdoings happened, listening empathetically, letting them know their entitlements, taking reasonable action. And one thing is really clear. Victims place more value on procedural justice and good treatment than they do on getting the right verdict for them, or at all a heavy sentence. In fact, all of the things that they want are procedural justice. And this is the point. From the police to the judiciary, the criminal justice system can easily deliver this kind of justice. And there should be two kinds of justice delivered by requiring, as part of their duty, police courts, the CPS, and everyone else to understand that this is a part of what they do. Just as important as to read the indictment out correctly, it is your job to deliver this simple but deeply appreciated justice. And if you don't, as a criminal justice professional, you are doing harm. You make participants feel worse. They are less likely to come to court again. They won't support the police. and they won't recover so well. The imprint of the criminal justice system on victims lasts forever. They will never have made public appearances before. They will never have been so much at the forefront in the hands of the state. Even if victims are among the few percent who get victim services and start to improve, if they go into the criminal justice system, they regress if they aren't treated well, because the state they're expected to take care of them doesn't seem to be valuing them. And this is really why these rights are so important. It's not just a courtesy to be observed when there's time. They are restorative. They tell people that on behalf of all of us, the criminal justice system is there to be fair and just to them, as it will be to their adversary. So these rights are really important. And the care of victims in these really simple ways is the other half of the justice. And so to do it, we should recognise and label victims as part of the process, as participants in it. Just acknowledge the reality that once the case has started, they can't get out of it, and they're trapped in a system they never wanted to be in at all, and deal with them kindly and ensure that they get their rights. It's really clear that after years of the code not being implemented, the victims' law is going to have to make it statutory, and it's going to have to make the rights enforceable. And much as I would wish this vision, which is a bit over the top, of a participant victim, but a good way of seeing it, much as I wish that that would do the trick, I think there has to be a duty on every criminal justice agency to deliver rights, and they need to be rewritten so they are rights and not concessions to be made if it's at all possible by the criminal justice agencies. Lots of adversarial jurisdictions have a special complaint system for breaches of their victims' code rights. Australia, in many of the states. But here, each criminal justice agency has its own separate complaint system, not limited to the victims' code. And frankly, getting a breach of the victims' code into the police complaint system is highly unlikely. And there's a triple tier one with the CPS. They're not about that level of complaint. What's necessary is a different complaint system. You have to go now all the way through the police one, all the way through the CPS one, whoever it is who you think is responsible. And you might not be right, because you can't always tell, particularly between the police and the CPS, who are responsible. You have to go all the way through, and if you don't get satisfaction, there is an ombudsman to whom you can go. But you need your MP's support to do that. And the Parliamentary and Health Ombudsman, who's charged with complaints about the criminal justice system, gets around 10,000 a year about health and 3 about the criminal justice system, because it is so convoluted and you need your MP. And, by the time you've gone through all of those layers, it's long, long ago. And you're probably re-traumatizing yourself by trying to persevere and getting something, not surprisingly, very, very few get there. So what we have recommended to the victims' law is that there should be, in every police and crime commissioner area, a victims champion. So kind of a little me, these people are little me, but a little victims commissioner for every PCC, and they should be the recipients of complaints, which have got to be done surely locally when they're about a local criminal justice system. And they should have a working policy of trying to put right what's wrong in the case itself. As I say, many people will not be able, will not go into the criminal justice system more than once ever. And it is very important, for instance, if they're not getting an interpreter who can adequately translate what they want to say in their statement, it is no good letting a cross-examination follow that suggests what they say in court isn't the same as in the statement because it's been badly translated. You don't need to complain about that later. You want the intervention of the victim's champion to make sure you do get an interpreter. So our notion is that that ought to be the working model, that ISVAs, IDVAs, victims hubs, whoever is there, and of course victims themselves should go try and get what they need, but if they can't, should go directly to the victim's champion, who would have an intention of setting up a lot of good contacts. So, for instance, that simple example of an interpreter, they would know the chief inspector, the superintendent to whom to go to and make a complaint, and then if it didn't work, they would be the people who took the complaint forward, and probably, if they couldn't get any satisfaction, it should go directly to the ombudsperson. It's quite a strange creature, the ombudsman, because it is funded to deal with criminal justice complaints and evaluated for that, but it doesn't. So we don't really need, I think, another body. We just need to get things there more quickly. And if the victim's champion fails, that looks like the right place to be. Should there be redress for breaches? I can tell you there are some MPs who think that failing to deliver victims' code rights should be a disciplinary issue across all the criminal justice agencies. There was even a brief whimsical reference in a press story to the Victims Commissioner being able to fine people who broke the rules. That I will not be doing. I do hope for a shift in vision, but undoubtedly it will have to be accompanied by a complaint system that has a real impact. The use of enforcement to implement the code looks important, but it is a shame, and I do think that agencies would support victims better if they did see them as the key participants that they are. And I suspect too that the criminal justice agencies would deal far better with victims if they got the resources to do that on this side of the case as well as on the other side. So there's a tiny bit of law on the participant victim that helps. Obviously the victim in their own case has a very different interest from yours and mine, despite the facade that the prosecution is carried out by all of us. The late Lord Steyn in the House of Lords in 1999 said serious crime should be effectively investigated and prosecuted, must be fairness to all sides. In a criminal case, this requires the court to consider a triangulation of interest, and it involves taking into account the position of the accused, the position of the victim, and his or her family, and the public. So what pleased me about that was this recognition of a separate interest from that of the prosecution that the victim had. He reiterated this in a case called A, which a lot of people will remember is in a very early case after the passage of the Human Rights Act. The guarantee of a fair trial under Article 6 is absolute. The only balancing permitted in respect of what a fair trial entails is to take account of the triangulation of interest, the accused, the victim, and society, and to do so proportionately. This triangulation recognises in a proportionate way that the victim has a role to play far closer than we, the detached public, are to the events and consequences. And there are a few international links really founded on the 1985 UN Declaration of Basic Principles of Justice for Victims that somewhat back the recognition of separate victim participatory rights, and there's a case in the European Human Rights Court that does as well, and I won't read the ratio, they are persuasive, as is the status of victim as participant, which is actually the law in Victoria, Australia. Following a report from the Victoria Law Reform Commission, the Victims Charter Act there says a victim of crime has an inherent interest in the response by the criminal justice system to that crime, giving rise to the rights and entitlements set out, and it acknowledges the victim's role as a participant, but not a party, in proceedings of criminal offences. The role, redefining the role, is intended to be a practical step, intended to get the CJS agencies to see that their rights should flow from that understanding. For most victims, their entitlement to be seen as a participant will be fine by information and support, but for some it will mean being able to challenge decisions that impact on them. I think we're reasonably used to this. The police and the CPS victims' right to review schemes let a complainant request a review of any decision which will end their case, for instance, the decision not to charge. And last year, the court added to that right to review fair opportunity for a victim to make submissions to the right to review scheme. The CPS said, actually, all the scheme allows is a request to review by them are what we would see as pass it to the next bloke along and he'll pass you his, but you don't have any rights to influence its outcome. But now you do. And that's an important step toward improving the role in charging and so on of a victim. The CPS don't promote it greatly. It's pretty early days, I suppose, but The Sun newspaper, which I read regularly, showed that 380 cases that were successful victims' rights reviews had resulted in 213 convictions. These are cases the CPS weren't going to take. 213 convictions, of which 41 were sex offences and 12 were major fraud. The CPS are quite risk averse at the moment, and their response was that of 185,000 decisions eligible for appeal, just 0.26% have been overturned. But then very few people know about the victim's right to review, and nobody's really going to exercise it in regard to something like a burglary, I don't think. So there is, a development in the right direction. It strengthens the victim's role in the whole charging decision. Remember from our research how devastating rape victims find charging decisions not to go ahead. It follows, really, the victim's right to a personal statement to be heard on sentencing, to be heard on charge. And we've said that in every charging decision over a particular level, there should be consultation with the victim. And the government agreed, and they didn't agree, and I don't know quite now where they are, but that's part of our submission to the victim's law. But nobody says that because it's their case, the victim's view is determinative at all. It's not about being a party. The authority's role is to make the decisions, but many, many victims want to be heard. And it's a recognition, again, of separate interest, which is really best expressed in connection with victims' rights to privacy under Article 8 of the ECHR. So this, again, comes back to sex offences principally. Prosecutors who find any private documents of the victim which they think might undermine their case or help the defence must, of course, disclose it to the defence. But the triangulation of interest recognised by Lord Steyn internationally allows the victim to ask for a proper balance to be struck with their privacy rights. This is an interest, if you think about it, not otherwise capable of being represented. The CPS can't represent the individual's privacy right, but they represent all the rest of us, and they have a role under the Criminal Procedure and Investigations Act to disclose, as I indicated. Nor does it undermine the accused, because a finding that the balance favours non-disclosure for the victim would just rule out an unfair advantage if that balancing exercise had been done properly. So this obviously relates to a lot of criticism of police and CPS demands for mobile phone data and for confidential health and other records of victims. A CPS internal review leads to the Guardian found that 65% of their demands for phone downloads 2 years ago was irrational and unnecessary. This brings the right further forward, doesn't it? Because it's not about disclosure, it's about an overextensive search for credibility issues, frankly, in sex offences. And so it's part of the end-to-end rape review, the pretty risk-averse approach to prosecuting the CPS, in which they look, first and foremost, at the credibility of the complainant, and we go back many, many years, get all of their records in order to do that. So this is not about disclosure to the defence only, it is about too broad a search now by the prosecution invading my privacy as a victim. So of course the CPS can't represent that at all, but there must be a fair balance struck. And there is, of course, a negative obligation on the public authorities to abstain from arbitrary interference with the right to privacy. And the judicial protocol is the kind of mirror image. Victims don't waive the right to the confidentiality of their medical records under Article 8 by making a complaint against the accused. The court must make sure that any interference is in accordance with the law and necessary in pursuit of a legitimate public interest. However, a pilot of legal representation for rape complaints to challenge intrusive disclosure demands suggests that sometimes, when the right to privacy is raised, the CPS just drop the prosecution. There is a case called Stafford, which gives the victim a right to be heard when there's a subpoena for confidential material, but that entire process is preempted and the complainant treated exactly as if they had waived the confidentiality of their medical records and so on, if you either give them or the case doesn't go ahead. And it's an example, like the victim's right to review, of the need to set out the right to a victim's voice in this statute as a participant in what's happening there and to be heard on issues of deep concern. The evaluation of that independent legal advice project for this purpose showed that the police and CPS actually acknowledged that by giving the victim legal representation it had been beneficial because it had clarified the issues at the outset, and in some cases, 50% in fact in this pilot, the requests had originally been over intrusive. Of course, this hasn't helped support for the CPS and support for the police in their dilemma about rape prosecutions. Now, however, their role in the adversarial system does mean the CPS can't represent the interests of the victims in disclosure, and so in part they're blamed for not doing it when they can't do it, which means that recognition of that separate interest for the victim and the participant is good for them as an organisation and good for the police too, because it clarifies their role and stops the blame for something that they are not responsible for. Long ago, in 2005, the Labour government proposed legal representation for victims in such cases, in homicide and in domestic abuse. 2014, this Ministry of Justice had a similar proposal, the Gillen Review in Northern Ireland and the Dorian Review in Scotland of sex offence trials all advocate legal representation in order for that victim's voice to become a real one, emphasising it's as a participant and not as a determinative party. So nobody could suggest that this is a fully realised new vision of the victim's role, but there is a really urgent need for victims to be recognised this way as participants with an inherent interest from the day of the crime right through the criminal justice process, entitled to the rights, the respect and the support of that role, which will help them personally to recover it. This is really important for our fellow citizens who've been harmed by crime, and they should recover. But equally, it's essential to have a functioning criminal justice system and to stem the flow of victims away from it and the risk of further collapses in public confidence. It is really cheering to me that as a practical proposition, that there is this bit of jurisprudence from Lord Steyn and from that recent High Court case about the victim's right to review for the voices of victims to be more acknowledged than before as separate from the state in proceedings that are essentially regarded as between the defendant and the state originally. So there is room for this participant victim with that participant victim's rights. So we should kindle a few more thoughts about this idea. We now are working reality in Victoria and definitely consider it in the victim's law. And if we feel we need better to inform ourselves, I would be all for a short fact-finding trip to Australia. Thank you very much.